Judge Winkler, you're on mute.
Oh.
All right. Good morning, everybody. Welcome to the First District Court of Appeals. We have 3 cases on the docket to be argued this morning. Our first case is In Re TS. Ms. Steer is here on behalf of the state of Ohio, and Ms. Moss is here on behalf of TS. Ms. Steer, you will have 15 minutes to argue. Would you like to reserve any of that time for rebuttal?
Yes, can I reserve 5 minutes, please?
Yes, and whenever you are ready, you may begin.
Thank you. Good morning, Your Honors.
Good morning.
May it please the court. Actually, I don't imagine I'm going to use up much of my time. This is a pretty straightforward case. The TS was in a discretionary bind over hearing to see if he was going to be bound over to adult court for felonious assault. At the hearing, Detective Bull testified that TS had told him that he fired a gun backwards and at the 2 men who he believed were firing at him. And the court found that when she made her statement, she said that he was acting in self-defense. However, in its written decision, the court said that there was no probable cause. Clearly, the court went beyond what was required at the probable cause hearing. At the probable cause hearing, all that the state needs to do is prove that there's some evidence, sufficient evidence that the defendant committed the act.
Ms. Steer, let me ask you a question that's been on my mind.
Yes.
Your argument, I'm sorry, I just got some weird message on my computer here. Under the new law, the state has the burden to establish, once there's evidence of self-defense, the state has the burden to establish that TS did not act in self-defense. Does that change the analysis and the argument, and especially the new case that you cited and brought to our attention? Because isn't it now, it's not really, we keep calling it a defense, but is it really a defense still? Isn't it something that the state has the burden on? And couldn't it have been that the trial judge found that there wasn't probable cause to support the state's ability to prove what it would have to prove for self-defense?
I think although the burden is on the state once there's evidence presented now, I think that it is still considered an affirmative defense. So I think that Hancock would still apply. And I think that the burden that goes to the state would only come into play once we got to the point of actually proving the case, if it went to either adult court or during the adjudication phase. I don't believe that there are any cases yet that have decided that issue, though, unfortunately.
Well, and I ask that because I know that even the courts after the new statute refer to it as an affirmative defense, but I guess I'm questioning whether that's really the right nomenclature anymore, because there isn't a burden on the defendant other than the burden of production to show some evidence of self-defense.
Right. I agree. I think obviously it's going to be a hot issue soon, right? Whether or not, I just think at this point, where the procedural posture of this case, that it's not really a ripe issue. I do think that that's going to be an issue, whether or not it's still considered an affirmative defense and exactly how it works as far as how courts consider it. But here, I think that the state just had to put on proof, and it did put on proof that TS knowingly attempted to cause physical harm by means of a weapon.
Let me follow that through. Let's say there was a case out there from the Supreme Court that said it is no longer an affirmative defense because the state has the burden of proof once there is some evidence of self-defense. Would your analysis in this case be different? I guess what I'm asking is, couldn't a trial judge say there is evidence of self-defense, therefore the state now has the burden, and I find that there isn't probable cause because the state there's not probable cause that the state can ever meet that burden that it now has.
I'm not sure that the court could go that far though, because I'm not sure, even with the state's burden, I don't know that at this point the state has any burden to prove anything beyond a reasonable doubt. For instance, if you take self-defense out of the picture for a second, when the state is just putting on evidence of a felonious assault, we don't even have to prove beyond a reasonable doubt that the actions actually occurred. So right then, we don't have that burden of proof. So I would imagine that the same would apply to the affirmative defense, and we would just merely have to put on the evidence, but the burden as far as proving that that he didn't act in self-defense wouldn't occur until the trial phase.
All right, thank you.
Really, I have actually no more left to argue other than that I believe that the state put on sufficient evidence, and unless anyone else has any questions, I'll just reserve the rest of my time.
Anyone else on the panel have questions?
No, thank you.
Thank you.
Ms. Deere, you will have 10 minutes when we come back. Ms. Moss, you have 15 minutes.
Thank you. Good morning, Your Honor. May it please the court, Jessica Moss on behalf of the appellee TS. We are asking that this court uphold the juvenile court's finding of no probable cause in this case and dismissal of the felonious assault charge. Now, a bind over proceeding is a critically important hearing, and the court does have to look at whether or not there's probable cause, as well as the evidence that attacks probable cause. And here in this case, if let's say we take the self-defense part off the table, we still have this issue of the Corpus Delecty rule, where there has to be some evidence apart from a confession to demonstrate the body of the crime. And here, the only evidence that the state put on was from Detective Bull. There were no other witnesses that testified at the probable cause hearing. And the testimony from Detective Bull, first of all, was that he couldn't remember, there's certain key details he couldn't remember from the interviews with TS, Grigsby, and Cook. But also, the only evidence of TS allegedly firing a gun was from TS's statement to Bull at a time where he was in the hospital, where TS was in the hospital recovering from a gunshot wound, and Detective Bull couldn't even know whether or not TS was under any kind of pain medications or was under any pain at that point. There was no shell casings of this gun allegedly used by TS, where the other two guns, the ones used by Grigsby and Cook, there were shell casings that were found. There was also no video showing TS shooting a gun. Most importantly, there's no identification of TS as the alleged shooter. Now, unlike other probable cause hearings, we have a witness that comes in to identify an alleged shooter. Here, that didn't happen. Detective Bull did not even ask Grigsby to come in and do an identification, and Cook said he was too far away and could not make an identification. So there was no identification of TS as being this alleged shooter. So when we look at whether or not the juvenile court had probable cause that TS committed this offense, even if we take off the self-defense issue off the table, there still wasn't sufficient evidence or probable cause of it being TS that allegedly committed this crime. And so that's where it's important that even though the court went further and talked about this self-defense issue, which we would assert that the state would still have a burden to put on at least probable cause that there wasn't self-defense, which didn't happen here, they didn't put on even the minimum level to show that there was probable cause that TS committed this offense.
Didn't he admit that he fired the gun?
So that was the testimony from Detective Bull that allegedly TS said. There was no video recording shown at the probable cause hearing. And again, Detective Bull couldn't remember a lot of key details about what happened during the interview. He couldn't even remember how many times TS was shot or where TS was shot, and had to.
The officers say that he admitted that he fired at the people behind him.
That was Detective Bull's testimony, but that's coming from a statement where, again, this is an hour or two after the shooting, where he's suffering from a gunshot wound and questioning how reliable that information is. But if the only evidence is TS's statement coming from Detective Bull, not even coming from TS himself, there still has to be something else showing the body of the crime, and that isn't established here. We have nothing showing.
We're probably talking about probable cause though here, are we? We're not talking about guilt or innocence.
Correct.
So that you don't think that's enough to establish probable cause, that he admitted to the officer that he shot at those people?
I don't know, and that's where the Corpus Delecty rule comes in, that you have to have something more than a person's statement to show the body of the crime. So if, let's say, there was something on video showing a person shooting the gun, that certainly would be something more than just the person's statement, but we don't have that. And while Grigsby and Cook talk about somebody shooting a gun, it's never identified as being TS. And so therefore it still doesn't show him being the one that allegedly committed this crime. We would assert that this situation is more akin to the In re DTF and In re CG, where it was the state's own testimony that they presented and identification that was not credible, which caused the court in both those cases to find that there was no probable cause because it was the confusion by the evidence presented by the state.
Ms. Moss, I'm correct, aren't I, that you are not making the argument that I made about self-defense and it being the state's burden, and maybe that was the lack of probable cause?
We would agree with that assertion. Here, I don't think it even goes that far because the evidence presented by the state, even at a minimum, doesn't establish that minimum level of probable cause of it being TS.
Thank you.
Let me ask Ms. Moss, if counsel was relying on self-defense, doesn't that presume that the crime of felonious assault was committed, and self-defense merely obviates any criminal responsibility for that crime?
So these are remarks made by defense counsel at the opening and closing. This was not evidence actually testified at trial from the defense, but it was only alluded to as a defense type capacity and not specifically what that was in terms of what came out from the defense in the opening and closing.
But it sounded like the court relied upon the self-defense in the statements of the court prior to dismissing the case. It sounds like that was the predicate to dismiss it, that this is obviously a self-defense case, case dismissed. I mean,
so the court did indicate that on the record, and I would assert that it goes beyond just the self-defense issue, but not having probable cause, which is what the court put in their entry, that there was the evidence was not sufficient to establish probable cause that TS committed the offense. And it's really important that the juvenile court in this probable cause hearing has to act as a gateway to determine what cases potentially should move forward to adult court or should stay in juvenile court or should be dismissed altogether if there wasn't enough evidence. The court, beyond just doing this, had other abilities to dismiss the charges pursuant to Juvenile Rule 9 and Juvenile Rule 45B in looking at what is in the best interest of the child and the community. And so taking all this information, the court certainly was within its ability to make this decision to dismiss these charges. For this reason, I would ask that you uphold the juvenile court's decision finding no probable cause for the felonious assault and uphold the dismissal of the felonious assault charge. Thank you.
Thank you. Ms. Steer, you have about 10 minutes left if you'd like to use it.
Thank you. To your point, Judge Winkler, if the defense is that he was using an affirmative self-defense, then by the very definition of self-defense, that means that he actually committed the act. So I'm kind of in between. There's two alternate realities that I'm arguing here. Either he didn't commit the act at all, as they argue, but there's plenty of sufficient proof, at least to get past the probable cause stage, that he did with his statements to Detective Bull, which the trial court must have found sufficient because the trial court took the next step and found that he had used self-defense. So we have that the court found that he had committed the act, probable cause that he had committed the act. As far as whether or not the self-defense, then the state had any burden as far as the self-defense, there was some evidence that I think would have gone to self-defense, and perhaps it could be called sufficient to at least rebut it at this point. And that was, I forget if it was Cook or Grigsby, stated he thought he saw the defendant in a car that had been stolen from him. I think it was a bootleg car that had been stolen from him. And he went behind him and he said he fired in the air. If that statement is to be believed, then that would negate any affirmative defense that the defendant would have had. And that's something that would be proven during trial. Anything about whether or not he was able to actually confess when he was in the hospital, whether or not his statements were admissible, all of that's going to the guilt or innocence phase, and it's premature to be talking about it in the probable cause. Detective Bull gave the statements that the TS said that he had shot at the people behind him, and that's sufficient to show felonious assault to at least get past the probable cause phase. There may be some other evidence that's going to be proven later, and if he wants to raise affirmative defense, if he puts on sufficient evidence of affirmative defense, then the state will disprove it beyond a reasonable doubt.
Ms. Deere, I want to circle back to the discussion that we were having. If this were a felony in adult court and it went before the grand jury, and the grand jury was determining probable cause, is it your position that with the way the law is now, that grand jury couldn't decide not to indict if they found that the person acted in self-defense? That's not appropriate for a probable cause determination?
I'm not sure that at that point, I don't think because our burden is beyond a reasonable doubt during trial, I'm just not sure that we'd have to put on sufficient evidence to disprove it by beyond a reasonable doubt at the grand jury.
Not beyond a reasonable doubt, but what if the grand jurors said, you know, the evidence is overwhelming that he acted in self-defense, and therefore there's no probable cause. The state's never going to meet its heightened burden. We don't even find probable cause.
I would imagine during a hearing then we would answer with at least some evidence disproving that at that point. Why
couldn't the trial judge have done that here? Just say the evidence is overwhelming that TS acted in self-defense. I know TS really hasn't raised this, so it might be an academic exercise, but I'm really struggling with the way the state of the law now and whether that's a legitimate consideration or not a legitimate consideration at the probable cause stage.
I think that had it been raised during the hearing, whether or not, I don't think that the judge saying that she thought it was affirmative defense or that it was self-defense, that didn't happen till the end of the hearing. I suspect had the state been on notice that that was going to be what the argument was, I would suspect that the state would have put on some evidence that it wasn't self-defense. For instance, going more into, you know, a shot fired up in the air, whether or not it's reasonable for you to think that you're under imminent harm, and then that you get to act in self-defense. I think that the way that this whole issue has come up, it's kind of the whole hearing happened, and then the defense counsel mentions self-defense at the end of the hearing, and then that's what the trial court decided. But I think that it was just premature to be deciding that, and I don't think that it was before the court at that point.
Thank you.
So the state would ask that the court reverse the juvenile court's probable cause determination and reverse this case. Thank you.
Any other questions for Ms. Steer?
No.
Not for me. Thank you.
Counsel, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion.
Thank you.
And Ms. Hayden, if you will let our next parties in to the courtroom.
Mary, nice to see you again.
Nice to see you. I'm still here. You guys are going to get sick of me today.
Well, I'm back.
Good morning, Mr. Thompson.
Good morning, Your Honor.
Our next case on the docket this morning is In Re TM. Mr. Thompson, you will have 15 minutes to argue. Would you like to reserve, oh, I'm sorry, I think actually, Ms. Steer, you are the appellant again, are you not?
No.
Oh, hold on, I've got too many cases in front of me. I was
This
right
was
the first time,
confirmed.
Mr. Thompson. Mr. Thompson, you will have 15 minutes. Would you like to reserve any of that time?
Yes, Your Honor, 3 minutes.
Thank you, and whenever you're ready.
Thank you. May it please the court, counsel. In this case, the trial court committed structural error when it denied TM his rights to a fair trial and due process. Specifically, the trial court favored the state by forming a fixed anticipatory judgment that TM should be adjudicated of felonious assault. It showed through its statements that it did not maintain an open state of mind in reaching its conclusion. Here, the procedural history of this case is important. This case was previously before this court and reversed because the trial court refused to grant TM a continuance to obtain the testimony of his witnesses. In the initial trial, then, it adjudicated TM without the benefit of his witnesses. On remand, the trial was essentially reopened at the point that TM's witnesses would testify. Therefore, the bias from the initial trial date in September 2018 is still relevant to the overall bias as well. There were 4 particular incidents indicating the trial court reached a fixed anticipatory judgment. First, when Angela West testified on cross-examination, defense counsel challenged her testimony with her recorded statement to police. The trial court said regarding the video, "Why are we watching this? What is the point you're trying to make? Can you get to it?" Now, this indicates a lack of interest in defense counsel's points on cross-examination, much like it had no interest in hearing from defense witnesses the first time around. Second, when TM testified, he said that Mr. Schmidt punched him first. He described the punch as a sucker punch. The trial court interjected without objection from the state and said, "That's a mischaracterization. It was just punching. Let's clear that up or rephrase the question." And while a trial court can choose to believe or not believe testimony, there was nothing objectionable about TM's statement that he was sucker punched. It was his personal opinion about the nature of the punch. To deny TM the ability to testify to his own perception of the incident is further proof that the trial court had reached a fixed anticipatory judgment. Third, when Jasmine testified on direct, defense counsel, having obviously observed Jasmine gesturing to show how Mr. Schmidt reached for TM's legs, started to ask a question. Defense counsel started to ask a question based on the gesture. The trial court interjected, again without objection. "I didn't see that. That's not accurate. You were leading the witness. Go ahead." Defense counsel has a duty to present the truth in court. The trial court made a record that there was no gesturing made by the witness. In doing so, trial court essentially made a record that defense counsel presented a falsehood to the court. This showed favoritism to the state, a further indication that the trial court had reached a fixed anticipatory judgment. Finally, when Jasmine testified about how close Mr. Schmidt initially was to TM, she first said 4 feet. When redirected by defense counsel, she corrected herself to 2 feet. Rather than simply reach its own conclusion about the distance, the trial court again spoke up, stating, "I think it's a little bit further, 2 to 4 feet." It may seem on its face like the court making its own determination, but what's happening there is the trial court is indicating that the witness and defense theory was not to be believed, again showing favoritism toward the state. Moving to the second assignment of error, regardless of what this court reaches about the trial court's bias, the fact remains that TM should not have been adjudicated of felonious assault because his adjudication was based on insufficient evidence and was against the manifest weight of the evidence. It should first be noted that the trial court reached the contradictory conclusion that TM and Mr. Schmidt both squared up and engaged in a mutual fight, but that TM was guilty of felonious assault. A mutual fight is disorderly conduct under RC 2917-11A1, It does not become a felonious assault simply because one party accidentally suffered a serious injury. Second, the trial court erred in relying solely on the foreseeability of injury from the incident. Much like the reasonable doubt standard, where every incident is subject to some imaginary doubt, any possible outcome of a fight could theoretically be foreseen. The question here, however, under the definition of knowingly in RC 2903.11A1 is whether TM was aware that his conduct would probably cause a certain result or probably be of a certain nature. In other words, was TM aware that his conduct would probably lead to Mr. Schmidt suffering a traumatic brain injury? Here, there is no evidence to indicate that TM knowingly caused the serious physical harm Mr. Schmidt suffered. Even if the state were to show recklessness on TM's behalf, doing so would be insufficient to prove knowledge. A reckless cause of serious physical harm would be an assault, not a felonious assault. For example, in State versus Berry, 2007, Ohio 7082 from the 12th District, the court found that although the defendant knowingly slammed a glass to the floor, which would cause a glass to break, it could not conclude that the defendant was subjectively aware his actions would harm his nearby wife. Furthermore, in State versus Hancock, 2004, Ohio 1492, this court found that a couple struggling over a phone, which led to the phone striking the alleged victim, was insufficient to establish knowledge of the harm. The events here are undoubtedly fortunate and unfortunate and sad, but they did not establish knowledge. We essentially were presented with 5 viewpoints on what happened. Mr. Schmidt was unable to testify about how he fell to the ground. He could only guess. Angela West changed her testimony from her statement to police. She initially confirmed that Mr. Schmidt tried to grab TM. TM grabbed Mr. Schmidt back, and they both went down, with TM falling on his back and Mr. Schmidt falling on top of TM. At trial, she claimed TM grabbed Mr. Schmidt from behind and fell back, causing them both to fall. The TM testified that Mr. Schmidt punched him first, and then TM punched him back. Mr. Schmidt grabbed TM's shirt, TM grabbed his shoulders, both fell, and then TM ran away. Alexis and Jasmine, who were allowed to testify on remand, both confirmed that Mr. Schmidt punched first. They said Mr. Schmidt went for TM's legs, and TM put Mr. Schmidt in a bear hug, and again, both fell. Until Angela West changed her testimony during trial, everyone who could testify about the fall agreed that TM fell on his back and Mr. Schmidt fell on him. The evidence clearly shows that TM did not knowingly cause serious physical harm to Mr. Schmidt. Even if this court concludes that TM acted knowingly, the weight of the evidence shows that TM acted in self-defense. Even the court concluded that TM and Mr. Schmidt squared up to fight. The evidence presented at trial shows Mr. Schmidt swung on TM first. Looking to the elements of self-defense, TM was not at fault in creating the situation giving rise to the affray. Specifically, Mr. Schmidt initiated the verbal confrontation and he swung first. For the same reason that Mr. Schmidt swung first, TM certainly had reasonable grounds to believe he was in imminent danger of bodily harm. Regardless of TM's size, Mr. Schmidt was an adult man, and although unknown to TM, Mr. Schmidt had a military background. Finally, regarding the amount of force used, all TM did was grab Mr. Schmidt. The fall was accidental, and the severity of the injuries was incidental and a freak accident. The state did not disprove TM acted in self-defense. Now, the bottom line here is that the evidence showed that TM was approached by an adult, verbally accosted by him, and then punched by him. As he was allowed to do, TM returned the punch. When Mr. Schmidt grabbed him, TM grabbed him back. Now, unfortunately, they both fell, and Mr. Schmidt suffered serious injuries. but TM did not knowingly cause serious physical harm to Mr. Schmidt. His actions were not reckless, and the actions he did take were justified by self-defense. He was adjudicated by a court that had reached a fixed anticipatory judgment in favor of the state. For those reasons, we ask that this court reverse and vacate TM's adjudication.
Are there any questions from the panel?
No.
Mr. Thompson, you will have 5 minutes left.
Thank you.
Ms. Steer?
May it please the court. To start off with, the first assignment of error regarding the trial court's, some of the trial court's comments. First of all, it's important to point out that at no point during any of these hearings did defense counsel object to anything that the trial court was doing, object to any of its comments. And when the case was remanded back to the juvenile court, there was no argument made about the juvenile court, whether the juvenile court should continue with the hearing. When it was presented after it came back on appeal in December, the parties told the court that they had decided that she could go ahead and hear the testimony of the two witnesses. That there was no argument about that. There was no objection to it. Interestingly, as part of when the case was reversed for a continuance, the two witnesses that TM was supposed to bring were two high school friends of his who were apparently there. Then when it came back on remand, it turned into two young girls. I believe at least one of them was his niece. I don't know if both of them were. And so the trial court had already found that he should be adjudicated, and then it listened to the testimony of the two young girls. And at the conclusion of their testimony, and after reading through the transcript, when they came back on the record, the trial court found that their testimony was less than credible, which explains why her decision didn't change. The state had already proven its case, and nothing that the defense put on changed her opinion. As far as some of the statements that she made, I think that you can read, when you're reading a transcript, you can misread tone or you can misread what's happening. As far as when defense counsel was showing the video, before she got to the part about Angela West's statement to police officers, she was spending time, it sounds like, according to the transcript, going through who's that person and who's that person who's that person with the striped shirt on and who's that young girl. And that's when the trial court said, what's the point of this? What are you trying to do? Let's move it along. And to try to get her to move to Angela West's statement, which was the relevant part that she was trying to use the video. And again, as far as the sucker punch comment, the court didn't call TM's testimony, didn't say that was wrong. She said that the trial counsel's characterization was wrong, and she asked that it be reflected that it was just punching. And then as far as the not gesturing, when Jasmine was testifying, I'm not sure, based on my reading of the transcript, that Jasmine did gesture. The way I read the trial court statements is that Jasmine didn't make any gesture about grabbing around the legs. And then defense counsel said, you're indicating that he wrapped his arms around his legs. And I think that the trial court properly, if that gesture wasn't made it clear on the record, so that when all we're left with is reading the transcript, we don't have a video, we can't watch the little girl testifying, then it's clear that she hadn't made the gesture. The same goes for the 2 to 4 feet. I think that happens a lot during trial when a witness is trying to judge what a distance is, whether it's 2 feet, 6 feet, the distance between the witness and counsel asking a question. I think a lot of times courts rightly say that's about maybe 2 to 4 feet, just so it's clear on the record for when we're reading it on appeal. So I think I think the court did nothing improper, and to the extent any of that could be read as maybe not the best way to phrase comments, I don't think that any of it demonstrates that TM was deprived of a fair trial. Moving on to the sufficiency and weight, the state had to show that TM knowingly cause serious physical harm to another. He didn't have to know that he was going to cause traumatic brain injury to Mr. Schmidt, which is what he did cause. Instead, he just had to show that his conduct would probably cause a certain result or would be of a certain nature. And if you are a 220 to 230 pound boy and you grab someone and pull him down, there's a good chance, there's a good probability that someone's going to get seriously harmed. I think the state put on sufficient evidence that he did act knowingly. As far as the weight of the evidence, there were a lot of different stories about what happened, but the court chose not to believe some of those versions. Angela testified that she was talking to someone on the porch, but what she thought she saw was Randy walking toward her, and then TM came after him. Randy turned back, TM grabbed him and picked him up, and they both fell to the ground, and Randy hit his head. This was backed up, even though Randy couldn't remember a whole lot of what happened because of his injury. He did say that he remembered that all of a sudden TM started swinging at him. So in Randy's recount, it's TM who starts swinging first, and then he protected himself. And then Randy said he tried to walk away from the situation, and the next thing I know, I'm in the back of an ambulance. So in Randy's version, TM is the instigator. TM started the fight. The TM story was that Randy grabbed him, and he tried to grab him and was just trying to keep from falling. He said that Randy was trying to pick him up, which again, if you look at I think at the time TM was 220 pounds. And when you can see on the police body cam, Randy is not that big. It's unlikely that that was what happened. The other two stories from the two girls didn't even corroborate what TM's story was, because in their telling, somehow Randy tried to grab TM around the bottom of the legs and pick him up somehow. And then they fell on top of each other, and then they rolled. I think one of the girls testified that they rolled the length of 2 houses down the street. No one on the body cam talked about any rolling. And notably, the trial court found that their testimony was less than credible because they were actually using the exact same wording. So she kind of thought that maybe they had like a little bit of prepared statement. So I think that the state put on sufficient evidence, and I think that also the finding wasn't against the weight of the evidence. As for the self-defense, that the two of them, that the court found that they were both maybe mutually fighting, that doesn't prove that TM had the right to use self-defense, that he felt he was in imminent danger. And even if he did, his answer to it was, went way beyond the mutual fight, if there was a mutual fight. There really was. I think the court said that, but I don't think that that the court necessarily meant it was an equal blow by blow. I think it was just a matter of, it was hard to see what was happening at the beginning when the men were facing one another. And then Randy turned away and was grabbed by TM and pulled down onto the sidewalk. So unless anyone has any questions, the state would ask that the court affirm the adjudication.
Any questions?
Nope.
Thanks.
Thank you. Mr. Thompson, you have 5 minutes remaining.
Just briefly, Your Honor, I'd point out that on the March 4th trial date, page 29, trial counsel did attempt to object to the court's statements, but was stopped by the court. Regarding the manifest weight and sufficiency, it cannot be forgotten that Mr. Schmidt is the one who approached TM, who was a child, who got in his face, and mutual fights and disorderly conduct do not have a severity of the injury element. And I would just say that common sense dictates that a fall would not probably cause serious injury. People tussle all the time. Plenty of assault cases involve people falling during a fight. Plenty of mutual fight disorderly conducts result in the same sort of fall. I think the least likely outcome of a fall would be a serious brain injury or a serious injury. And that is not a outcome that is probably going to happen, and not one that would rise to the level of knowingly.
You indicate your client is a child. I think in the normal use of that term, a child is not 220 pounds.
He is a larger than
fully
average child, yes.
Well, even that is a bit of a stretch, but I mean, there was a big disparity between the two of them in terms of weight and height and so on, was there not?
Yes, there was. Nevertheless, a fall between people, even if you considered TM to be a man's size, is not a serious injury from a simple grab and fall is not something that you would anticipate that would probably happen. I have nothing further if there's no further questions.
No questions.
All right. Thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion.
Thank you, Your Honor.
Thank you.
Thank you. And Ms. Hayden, if you will bring in our last parties to the argument this morning. Good morning, counsel. Would you like of your 15 minutes to reserve any time?
I would like to reserve 5 minutes, please.
All right, and whenever you are ready, you may begin. And this is the case of State versus Sellers. Also, we did receive the request from the state of Ohio to supplement the record. Is there any objection from the defense on that request?
No objection, Your Honor.
All right, we will consider that at the same time we consider this case. But whenever you're ready, and remind me, how many minutes did you wish to reserve?
5, please, Judge.
Thank you. Whenever you're ready.
All right, thank you. May it please the court. Ms. Steer. The manner in which Mr. Sellers' convictions were attained in this case requires redress. And in particular, I would like to focus on the third assignment of error regarding waiver of counsel. So the trial court's efforts here, while commendable, did not substantially comply with the requirements of Criminal Rule 44 and Ohio Supreme Court case law. The requirements of Martin and the predecessor case Gibson should be zealously enforced by this court, particularly because the proceeding pro se is so serious. So as you know, Martin requires that the defendant, before validly waiving his right to counsel, must be informed of, and I'll go through them in this case to say what happened. Number one, the nature of the charges. And here, Mr. Sellers was informed of, at the pretrial, one of the pretrial hearings, that he faced the weapons under and the aggravated robbery. But if we confine the colloquy to the pretrial proceedings only, actually most of the Martin factors were not met. Even with the supplementary transcript you have, most of what he was informed was when trial was already underway during voir dire. So number one, the nature of the charges was partially complied with. Same with the statutory offenses included, partially complied with. The range of allowable punishments was not. He was told he was facing 17 years at one of the pretrial hearings, and that was it. So no range was provided whatsoever. The possible
is the requirement that a range be provided, or just the maximum?
The Martin case and Gibson specify a range, Your Honor. The fourth factor is the possible defenses to the charges, and while, again, it's during voir dire, so it's not really appropriate to assess this, but he was told that there might be affirmative defenses available that he could prove by a preponderance, and that was it. But he was not told what the defenses might be. And then the fifth factor is potential mitigation. That factor was not visited by the court at all. And then the sixth is sort of a catch-all, but still important, any other facts necessary for a broad understanding of the matter. So Mr. Sellers submits that the court, again, while commendable, while the court did take the time to caution him strongly and try to steer him away from proceeding pro se, just like the second district held in the Klein case, that these Martin factors must be adhered to. And even if the colloquy was good, if the factors are not met, then the waiver was not knowing, intelligent, and voluntary. And although it's not dispositive, there's also the fact, it's just an additional factor, that the written waiver does not appear in the record. So this court has said in other cases that that's not required and it's not reversible error on its own. We submit that it's just one more factor, that the Brooke case out of the Supremes does require that the waiver be filed with the court. And viewed in the totality, this is just one more reason why this case should be reversed and remanded for a new trial. The problem is that, like in the 8th District Ricks case, we don't know if it was a boilerplate waiver that was ineffective, like in Ricks. This court cannot assess it because it was never filed. So the fallout, which if we're going to look at the additional admonitions the trial court made during voir dire, then we would submit that we should look at the additional things that happened with Mr. Sellers' representation of himself during trial. And really, it should be limited to pretrial. We will concede that. But if we don't look at, the train wreck that was his representation, then we don't look at the additional things the trial court said to him when trial was already underway. If there are no questions on that assignment, I'll move on. Okay. Next, the first assignment of error concerned the motion to suppress, and the assignment is premised upon the requirement that the Miranda warnings should have been given when Mr. Sellers was questioned in the hospital. So as you know, the key inquiry is, was he being subjected to custodial interrogation? We would submit that he was. The hospital room was tiny, had one point of ingress and egress, and there were officers that were right outside that door. And, there's some dispute whether they were posted outside that door or simply kind of hanging out there. And, the fact remains that Mr. Sellers was not allowed to go out and get a drink of water or go to the bathroom. So that would suggest that the officers were keeping him confined to that room.
Well, was that caused by the medical people or by the legal people? The fact that he was somewhat confined and not allowed to walk around?
Judge, all we know from the record is that he asked the police officers right outside the door if he could leave, and they were the ones who said no. So as far as the record establishes, it suggests that it was law enforcement who was keeping him there. Mr. Sellers was questioned by 4 different officers, and Detective Longworth's admonition that he was not under arrest is not dispositive. We know that's a familiar tactic. Longworth brought another officer with him, Zeller. So as you know, the more officers that are there, it's a higher show of authority. And then the officers, like we said, outside the door remained close by, and one seemed to take a picture of him with his phone. Mr. Sellers was not given any medical treatment while he sat with literally a hole through his hand for the duration of the officer's interview. Detective Longworth's supposition that, well, it must not have hurt that bad is kind of incredible, considering he literally had a hole through his hand and the detective has never been shot. So that was kind of not believable. And that lends to the coercive nature of this, the intense pain that he would have been in, the difficulty of just wanting to get that questioning over with. So in sum, we believe the totality of the circumstances counter the assertion that Mr. Sellers was not in custody, and that Detective Longworth's failure to administer Miranda warnings at any point was fatal to the statements that were drawn out of Mr. Sellers from that interrogation. And then just quickly, with the second assignment of error, sufficiency and weight, really the aggravated robbery, there was no theft offense. The only things that tend to, even suggest guilt are the fact that he went in with the gun, but, Mr. Sellers went in and pointed the gun. The testimony was at the men, not at the store clerks. The supposed statement of, y'all know what time it is not enough to show beyond reasonable doubt that he intended to rob the store. In fact, his alternate explanation of knowing this guy, Mr. Davis, and wanting to confront him does make sense and the facts do fit. And that goes more to the weight, but Mr. Davis was a known man on the streets of Cincinnati. Detective Longworth knew who he was. And it was weird. He ran off. He was the hero here, but he ran away from that UDF and he took the gun with him and he didn't contact the police afterward. What does all that say? And the state did not call him to subpoena. We submit because he was not a credible witness, because he was in on this. So that most of that goes to the weight. I would say that the no theft offense goes more to sufficiency, but the alternate explanation would suggest that the weight of the evidence supports, rather does not support, the aggravated robbery conviction. If there are no other questions, I'll reserve the remainder of my time.
None.
Thank
You
you.
will have about 9 minutes when we come back to you. Ms. Steer?
Good morning, counsel. May it please the court. Let me start with the waiver of counsel first. I don't think that Martin can be read to require an exposition of every possible sentence that the defendant faces. I believe it says a range of sentence, saying that Sellers faced 17 years was substantially complied with that requirement. When you read through the assigned judges, it started on October 22nd. There was first a hearing before the assigned judge, but actually these discussions started before that. On August 14th, 2018, is when Sellers first started saying that he wanted to represent himself, that he wasn't happy with counsel. Some of the answers he was giving as the trial court tried to inquire into his reasons, he started citing the UCC, so the trial court got concerned about his competency. So the trial court ordered a competency report. When they came back a month later, he was found to be competent, and she again mentioned he again wanted to represent himself. So the trial court discussed it with him and also talked about having standby counsel available to him. And then finally on October 22nd, the assigned judge went through and talked to him about his waiver of counsel, talked about what he was facing, what had been offered as a plea agreement, the different crimes the different offenses that he was facing. He was he was not wanting to listen to the trial court. He was obviously a little angry that they had questioned his competency, but at the end of it, the trial court indicates that he signed a waiver. Granted, that waiver isn't in the record. Unfortunately, it didn't. The entry that I did find that was from the trial court was in a number that was very far off from the trial court number here. So I have no idea where that waiver ended up going. The case eventually was sent to a visiting judge on October 22nd. The visiting judge again went over, not to the same extent as the assigned judge, but he went over what his role was going to be if he acted as his own counsel, and he also indicated that there was a signed waiver. I think that this more than substantially complies with what's required to have the defendant waive counsel. And obviously under Martin, the lack of a signed waiver in the record, because it's not a constitutional requirement, it's not necessarily fatal to the waiver. And also, just real quick before I move on from this, I don't think that we can look at how he performed afterwards, because obviously we would never have an argument about waiver of counsel for all the cases when a defendant wins. Anytime a defendant loses a case when he's representing himself, you'd be able to argue maybe he didn't do the best job that he could as counsel. If I could move on to the first assignment of error regarding the motion to suppress. So Miranda is only required if he's in custody, and it's how a reasonable person would have understand his situation. In Brand, this court found that while it would be probably better practice in most cases in a hospital that the defendant is Mirandized, it's not necessarily required. Brand is a lot different.
In Brand, they found that, in fact, he was in custody, and
Yes.
it was a custodial interrogation. I know that you addressed this somewhat in your brief, but, and maybe this is where you were heading. How do you distinguish Brand from this case?
I think that there are lots of distinctions. Things that were pointed out by the court in Brand were that Brand, I think it was a woman, I'm not sure, but I think the defendant was a woman, went to the hospital after an accident. Even though she was taken there in the ambulance, police were on the scene of the accident because I think it was a suspected OVI. Her freedom of movement was restrained because she was on a backboard and she was confined to a cot.
But that goes, I think, to Judge Sunderman's question. That wasn't, the police weren't restraining her because of her injury. I mean, just because her injury was that severe, is that really part of the Brand equation?
Well, only because Brand cited it. I agree. And I would urge this court to follow the lead of King and Pyle, the cases that I cite in my brief. King is from the 3rd District, 2012, Ohio, 1281. And there they said you look at the reasons for the restraint, and the restraint in King was by the hospital and not police. And then in Pyle, a 2nd District case, 2003, 6664, the suspect wouldn't, they said the suspect wouldn't have reasonably thought he was in custody where he was brought by medics. He was restrained for medical treatment, and there was no evidence that the trooper kept him from leaving. If you look at those cases, you can distinguish Brand from this case because here Sellers brought himself to the hospital. He'd been shot in the hand. He appeared at the hospital on his own accord. In his testimony, he states that I believe the way he stated it, he wasn't even lying in the bed. He was sitting on the bed. And despite in Brand had indicated an unwillingness to answer questions. She also complained a lot about pain. Although Sellers testified that he didn't want to answer questions and that he was in pain, there's no evidence of that other than his statement, and the court could have found that incredible. When you listen to Detective Longworth's interview with him, he doesn't sound like he's really struggling. He's a soft-spoken person. That comes up at the end of the trial, that he's a soft-spoken person. And at no point did he ask Detective Longworth, or at no point, despite what he said during his testimony during the motion to suppress, he never said that he was in pain. He didn't tell Longworth that he was in pain.
But was he free to leave?
I think he was there. He was still getting medical treatment. I think they had given him gauze for his hand, but he hadn't been finished with his treatment. So I don't think that the police were keeping him there. I think he was waiting for his treatment. And although he made statements that there were police officers outside his door, that someone took a picture of him, obviously that was his version of the story. As Detective Longworth explained in his testimony at University Hospital, there are UC police officers, there are Cincinnati police officers who are assigned there as on duty. But they're just there in the hospital. And Detective Longworth even said that, the room that he was in was not the trauma bay one where it's really confined. He thought it seemed like it might've been bigger, I think, than 12x7. And there was no door. There was an entry opening, but there was no door that was shut. So other than Sellers' statement that someone told him he wasn't allowed to go to the bathroom and that he couldn't get water, there's no other evidence that he was being held there. And nothing in his interview with Detective Longworth indicates any unwillingness to talk or that he was in any pain at any point. If I could move on real quickly to the second assignment of errors, as far as sufficiency and weight. I cite in my brief the Eccles case, which is also from this court, where a man walked into I think a futon store with a knife and said, "Be cool, baby." And this court found that was sufficient sufficient evidence of an intent to rob. Here we have a man who walks in with a mask over his face, brandishing a gun, who points it at the counter and says, "Y'all know what this is." the wording kind of changes depending. It's either you know what this is or you know what time this is. Clearly, that's sufficient evidence of someone coming in and attempting to rob the store, or robbing the store, attempting to commit a theft. His story, when you're looking at the weight, his story just didn't add up. And that's what Detective Longworth testified to. His story was that he had a beef with Davis, who was in the UDF store, that he saw him in there, so he wanted to go in and scare him with a gun. As Detective Longworth points out, first of all, he approached the UDF with the mask already on. There's at no point when you're watching the video, you don't see him put on a mask immediately before he walks in. He has the mask, a bandana already pulled up. Detective Longworth also testified that there was no way that he could have seen Davis in the store until he was right up there. So he had already made up his mind that he was going to go into the store with a gun and with the mask on. Secondly, third, I think just logically, it makes no sense if you're trying to scare someone that you hide your face from him. That doesn't really make a lot of sense. And his actions that he took after the crime indicate his guilt, because he ran and he went to his girlfriend's house. He hid his clothes in a dumpster before he went to the hospital. All of these things, as Detective Longworth testified and as the jury found, indicate a level of guilt. As far as the discrepancy between what one of the clerks said in the UDF store, she testified, or she told police officers that she thought he was in there to rob the store. But then at trial, she said she didn't think he was because he wasn't pointing the gun at the clerks. However, when you watch the video, it looks like the clerks and two of the customers are up at the counter at the same time. So I'm not sure how she could tell who he was pointing the gun at. And by her own testimony, she took off and she bolted to the back right away. So she wasn't able to see exactly what happened afterwards. So I don't think that her testimony necessarily makes the fact of a robbery incredible. So unless there are any other questions, the state would ask that his conviction be affirmed.
Any other questions?
Thanks.
You have 9 minutes remaining.
Okay, thank you, Your Honor. I'll start quickly with the waiver of counsel. So, we would submit this case is more like this court's decision in State versus Lowe, which I did cite in my brief, but the citation is 2016 Ohio 3423. And in Lowe, the defendant vacillated about representing himself, and then he ended up saying he was going to. And this court, after looking at the record, said that there was not quite enough to demonstrate knowing, intelligent, and voluntary waiver. This court said that although the trial court did explain the challenges of self-representation against an experienced prosecutor and the seriousness of the charges, the trial court did not explain the offense, the range of punishments, possible mitigation, defenses, or other pertinent facts. Here we have a little more that was said, but if you look at the Martin Gibson factors, again, potential mitigation, not mentioned at all. Possible defenses, not mentioned at all. Range, only the max was mentioned. And any other facts essential for a broad understanding, there's a decision out of the 12th called Kievman, Kievman. It's 2014 Ohio 3008. And in that case, they discussed this catch-all factor and said that the defendant did not have a broad understanding of the case. And I think the same applies here when you look at Mr. Sellers, when you do look at that hearing that that counsel supplemented the record with, he was impatient. He kept saying, why are you asking me these questions, when the court was trying to engage in somewhat of a colloquy. He did not have this broad understanding. It was quite evident. And again, we have to look at all of the Martin factors. You can't just say a few were met at the end. It's substantial compliance. It's not minimal compliance.
But in Lowe, as I read Lowe, all the trial court did there was told him he was facing serious charges, and no discussion at all about punishment, what the maximum sentence would be or otherwise. And isn't that different than here? I mean, here there was a discussion of the penalties and the nature of the charges. And I guess I'm just questioning you on Lowe and whether that really is guidance for us.
I think Lowe, that's why I had stated, Your Honor, that, Lowe, there was a bit more here than in Lowe. And again, it would comprise only partial compliance with Martin, which if you look at that, the second district's decision in Klein, you can have a commendable, even thorough explanation of the perils of proceeding pro se. But if all of these Martin factors are not ticked off, it's not enough. And the same with here. When you completely omit the defenses and the mitigation, that's 2 of the 6 factors entirely not mentioned. That's a problem. With the motion to suppress, Pyle, do we have evidence that he was kept from leaving? They didn't in Pyle, but we do here. He was not allowed to leave the room, and it was by law enforcement. The reasons for the restraint, allegedly he was kept in there because he needed further treatment, but he didn't get that treatment I think it took him 4 hours to get treatment. So, and the whole time the police were in there, detectives, he was not treated. So it does suggest that he was not being treated. It was being held off because he was being questioned by the police. And to say that he didn't seem like he was in pain is kind of incredible because he, for one, Sellers did testify that the detective didn't turn on his recorder until he said, I'm in a lot of pain, I don't want to talk. And then he turns it on. So there was that. But, he had a hole in his hand. To say, you can tell from the timbre of his voice, he's fine, is kind of difficult to believe. Of course, he would have been in pain. And then, briefly on the sufficiency and weight assignment, Davis was walking in and out and it was twilight, or I'm sorry, it was the early morning hours. So it was dark out. The UDF was very well lit. You can see in the video, Davis walking in and out, in and out. So you could see him, I'm sure, from outside and identify him. Mr. Sellers was not wearing a mask. It was a bandana, which a lot of people have on hand, especially if they sweat or something like that or blow their nose. Bandanas are common. It was not a mask, no matter how many times you call it a mask. And then Detective Longworth, I urge you to take a close look at his testimony. He was not that credible. He kept hedging a lot. He didn't want to give any leeway when he's being questioned, to the point of not being believable. So if there are no further questions, we would just ask that reverse and remand for a retrial or a discharge as it sees fit.
Any questions from the panel?
No.
Actually, let me.
Counsel, thank you both very much for your. Oh, Judge.
I have how much time does she have left?
Yeah.
How much time does she have left?
She has 4 minutes left.
All right, I have a question then.
Sure. Yes.
All right, you went over the Martin factors. In this case, the judge said, okay, the maximum sentence is 17 years. And I know they're factors, but is there any significance to be taken from the fact the judge sentenced Mr. Sellers to a minimum sentence of 6 years in the Department of Corrections? If the judge told him, you may get 17 years and ended up sentencing to 6, does that matter? I mean, he didn't say you get 3 and then sentence him to 6.
Right. I would say that as far as it does not matter, because again, if like the state says, we don't look at anything that happened during trial, and then certainly it would be not sentencing either, to assess the voluntary knowing intelligence of the waiver, then the fact that whatever he was sentenced to is also irrelevant.
Okay. And my final question is, this always bedeviled me when I was dealing with a pro se defendant. You have somebody standing there in front of you, standing on their constitutional right to represent themselves. And you went over the possible defenses. To what extent do you think the trial judge has to go? I mean, obviously there are potential defenses, but all the judge has in front of them is an indictment. So are you saying that the trial judge needs to go over every possible defense that Mr. Sellers may have had? I'm just interested in what extent you think the judge needs to go. I wrote down, okay, well, maybe it's self-defense. Maybe it's not guilty by reason of insanity. Maybe it was duress. Maybe he didn't do it. I always told people that was the best one if they didn't do it. or voluntary intoxication. I know it's not a defense, but it might mitigate. So to what, how far do you have to think the judge has to go?
I would say that at least some mention of the applicable defenses on the fly would be closer, but probably a best practice would be a bench card that, just like during Crim Rule 11 colloquy, you have these certain things that have to be ticked off, strict compliance for the constitutional rights and substantial for non-constitutional. If there is a bench card, they just recite by rote the possible defenses and possible mitigation to cover themselves. That would be an easy way. Just do it as a matter of course to comply with Martin, and then we'd never be here on this issue.
But do you think that's required to do all that? You think it's-
Under Martin, yes.
But let me ask you this. Are you suggesting that the trial judge should talk about defenses that would never apply in a particular case? And isn't that misleading?
That's a good point, Your Honor. So it may have to be tailored, and maybe it cannot be boilerplate. And this is something that perhaps needs to be revisited by the High Supreme Court to flesh out what exactly is required under Gibson and Martin.
Any other questions?
No.
Thank you, Your Honors.
Thank you. Thank you both for your arguments this morning. We will take the case under submission and give you a timely written opinion. And that will conclude the arguments this morning for the First District Court of Appeals. Thanks, everybody.
Thank you.